8 parts of a lawful contract. Number 1. Parties competent to contract. The parties to a contract should be competent, being of the age of majority consent, of sound mind, and not disqualified from contracting by any law to which he is subject. A flaw in capacity may be due to minority, lunacy, idiocy, drunkenness, or status. The status of the parties should be of like kind, being artificial legal person and artificial legal person, or living man-woman and living man-woman, allowing 2 or more parties but never a mixture of these kinds. Number 2. Free and genuine consent. The consent of the parties to the agreement must be free and genuine. The consent of the parties should not be obtained by misrepresentation, fraud, undue influence, coercion, or mistake. If the consent is obtained by any of these means, then the contract is not valid or lawfully enforceable. Number 3. Full disclosure. When negotiating a contract, full disclosure is the act of providing all material information or telling the whole truth about any matter which may influence the decision-making of the other party or parties before they decide to enter into a contract. 4. Sufficient consideration. The consideration is something of value possessed by the parties that is brought to the contract table. This something of value is bargained for and given in exchange for a promise or performance. The parties must each receive a benefit and each suffer a detriment. To be enforceable, a contract must have sufficient consideration. A contract is unenforceable if it has insufficient or unequal consideration without agreement. A signature, autograph, is something of value. Number 5. Certainty of terms. The terms and conditions, or simply the terms, of the contract must be fully disclosed and agreed upon, and must be certain and fixed. For example, not variable as with interest rates. Number 6. Meeting of the minds. A meeting of the minds, consensus ad idem, occurs between the parties when they recognise each other, understand their mutual obligations, and agree. This meeting of the minds can only occur between like kinds in status, man-woman with man-woman, or when these are acting as legal person with legal person. A corporation and another corporation may enter into contract by way of accommodation parties, and a sentient being may enter into a contract directly, but a corporation and a sentient being together cannot enter into a contract as they are not of equal status. Number 7. Signatures and autographs. Written contracts between artificial legal persons must carry the wet ink signatures of the parties, because a wet ink signature is an accommodation from a living man, woman, declared or not. Written contracts between sentient beings must carry the wet ink autographs of the parties and or living identification such as a thumbprint. Living status is recognised by a thumbprint, or more often by an unambiguous declaration with the autograph, such as authorised agent, written below. Number 8. Privacy of contract. A contract exists only between the parties. No third party can obtain rights contained within a contract or buy or sell a contract without the express permission of the original parties.